Amber Heard has filed her appeal in the defamation verdict. She is arguing, just a couple highlights, that the exclusion of some of her therapy notes in which she reported being abused by Depp resulted in an unfair trial. They were ruled inadmissible by her judge. She argued that the trial should have taken place in California, not Virginia, where the couple lived together. He filed in Virginia because that's where the Washington Post has offices, and they have a more favorable defamation statute for him. And now she wants a reversal or a new trial. So
not on those issues.
What do we make of her chances? Go ahead, Mark. Sorry.
Not on those issues. As Arthur said earlier, the appellate court, they're generally not in the business of reversing convictions. And, they'll say something is error, but then say, well, it's harmless error. It wouldn't have made a difference. And I think if they find either the venue issue or the notes not being admitted to be problematic, they're going to say, well, that wouldn't have made a difference in the outcome of this case.
Well, I think the venue issue, that stands on all four. That's not a problem at all. If he's allowed to file in a venue that's more favorable to him, then he's allowed to do that. What's admissible to a jury regarding those notes is very much in the discretion of the trial judge. We don't know exactly what those notes say, or I don't.
Wait, I do. I just got an update on that. I'll tell you what's in them. Okay. Here's the update that we just got I asked Canadian Debbie, why were the therapy notes
Canadian Debbie?
It's
good to know.
Canadian Debbie. She's got all the answers. She used to be American Debbie till she married a damn Canadian, and then had a bunch of damn Canadian children. Now she lives in damn Canada.
All right.
So Heard's legal team was unable to admit the documents into evidence due to hearsay. What's allegedly in them? They're in June of 2022, Heard gave NBC numerous documents from a doctor for a Dateline interview. She said they represented years, this is her quote, years and years of real-time explanations of what was going on. She says, there is a binder worth of years of notes dating back to 2011 from the very beginning of my relationship that were taken by my doctor, who I was reporting the abuse to. One 2012 instance, according to Dateline, in which Depp allegedly, according to her, hit her, threw her against a wall, and threatened to kill her. 8 months after that, Depp allegedly ripped her nightgown, threw her on the bed. In 2013, he allegedly threw her against a wall and threatened to kill her. So she wanted the notes of her speaking to the therapist writing the notes down, to be admitted. Technically, that's double hearsay.
Yeah, it doesn't come in legally. Again, I don't think that the court's going to find that it was error, and I certainly don't think it would have made a difference. These jurors didn't find her believable. She screwed up. She chose to just deny things that she should have admitted. You put the poop in the bed. Just say you did it and say you're embarrassed. Just admit the things that you did, like he did, and you would have been found to be more credible. But the fact that they found her void of credibility certainly hurts her chances on appeal.
It's so true. Wait, Arthur, now listen to this one. So the other thing that I found interesting on her appeal, she claims that, you remember how the jury did find for her on one count? Mm-hmm. They found for him on all of his counts that he had been defamed by her. And she cross-sued against him, saying, you defamed me by saying that you didn't abuse me and that I was a lunatic. And they said, no. Oh, wait, there's one that we say, yes, he did defame you. His agent defamed you, and that's attributable to him. And she said that cannot be reconciled with the jury verdict in favor of Depp. She said to find in favor of Depp, the jury had to have concluded that Depp did not abuse Ms. Heard, and that Heard knowingly lied in accusing him of abuse. I agree with that. Well, she goes on to say, but to find in favor of Heard, the jury must have concluded that Heard told the truth about being a victim of domestic abuse by Depp. Accordingly, the verdict against Heard cannot stand. So I pulled that one piece of the verdict that went her way. All right. And this is the story. First, just as a reminder, he was awarded $15 million by the jury, $10 million in compensatory, $5 million in punitive, and they awarded her $2 million in compensatory. Hold on a second. Where is it?
So that's what he's saying is an inconsistent verdict.
Here's the thing. Depp's representative, Adam Waldman, had defamed her, she said, when he called her abuse claims a hoax in a British newspaper. But that claim went on to say that this is the one where they basically said he made up the story that when the police were coming to his apartment or to her apartment, she ran around knocking things over and trying to make it look like abuse had just happened. This is what this guy, Adam Waldman, allegedly said, that Amber Heard ran around trying to create the look of an abuse scene. And that's how crazy she was. She, knocked shit over and like spilled wine. And the jury said, we don't think she did that. When you look deeper into what that claim actually says, it does not undermine a conclusion that her abuse claims were false.
It's not an inconsistent. Mark and I deal sometimes where a jury comes back guilty on one thing and not guilty on the other. And you can't find the guy not guilty of possessing a gun, but guilty of shooting the guy in the head, right? It's an inconsistent verdict. But here, because of the fact scenario you just laid out, that's not gonna.
I'll tell you one thing I find slightly compelling, but it's not going to affect her appeal. I do find it interesting that a British judge made a finding that there was abuse in this relationship.
And that's in here. Just to point that out, Mark, tell us why you're telling us that.
I know it's in there, and I know she's raising that issue, but I don't think it's going to help because a factual finding made by a judge across the pond, another trier of fact, has, I think, almost no relevance to what this jury is, what they decided. So to say that another judge somewhere else found that there was merit somehow means that she didn't get a fair trial because she was allowed to write about abuse. I don't agree with that. But from the court of public opinion, my feeling going into this trial was, well, can't she write that op-ed piece about her experience because she feels abused? There's certainly enough that a judge found it to be in another place. Why can't she have that freedom of expression? And now is when you bash me, Megyn, and say, because she lied all about it. And that's what the judge.
Well, she is raising both of those issues, Arthur. She's saying what he said. A judge across the pond said he did abuse me, or that there was at least enough that I can say that he abused me. It's not defamatory for me to say it. And then secondly, she's raising this claim saying, I am allowed to have an opinion. If it's just opinion, if I say, I think so-and-so has an STD, it's just my opinion. That's not actionable. But if I say so-and-so has an STD, right?
I like this argument. Before Arthur gives his, I'm telling you from day one, as an advocate of the First Amendment, this to me was the most compelling argument that she had, that whether she technically is found to be an abuse victim by a jury or not, it's not about that. It's her experience. And if he yells at her and he throws stuff, that she can write from her experience to be an abused victim. She can write that. And I
as
think
a legal matter
under the First Amendment.
As a legal matter. That's the thing, Arthur, because, well, and who knows, because maybe the jury doesn't have to explain what it found was or was not abusive. They may not have believed any word she said about alleged abuse. And so maybe they concluded your opinion is based on absolutely nothing. You can't, that was an opinion. It was too close to fact. But anyway, back to my example, I believe so-and-so has an STD is okay. So-and-so has an STD is much more problematic if he doesn't actually have it. And she's trying to say, my experience was I was abused. That's opinion. And she says in here that holding that this was not protected opinion, if allowed to stand, undoubtedly will have a chilling effect on other women who wish to speak about abuse involving powerful men.
I agree.
And, Megyn, as you know very well, I've been living with this defamation stuff with Professor Dershowitz and that whole thing. I mean, when I say living with, I know more about this than I would ever want to know. And she does have a leg to stand on. But I want to go to what Mr. Eiglarsh said in the very beginning. Appellate courts need really smoking guns to flip a jury's verdict. Our whole system is supposed to be set up so that the citizens make the decision, not the judges. Yes, could she say, look, a judge across the pond said this, and therefore I can't be that crazy? Yes. Is that enough? No? I mean, in my opinion, that is not going to be enough for them to flip the verdict. But let
me just jump in there. I totally agree with that. Different evidentiary standards, different legal standards. That judgment in no way precludes this Virginia judgment. But speak to that second thing about opinion versus fact and how the alleged chilling effect.
Well, as Mark is saying, I mean, we want people to be able to speak their heart, right? To speak what they really feel. But if you speak what you really feel and what you're saying is an outright lie, well, then you lose you lose that privilege that we have as Americans if that outright lie is going to then hurt someone and really hurt them in a way that's demonstrable. Not that it hurt their feelings, but where they've lost money, they've lost jobs, they've lost family members, people don't speak to them anymore. And, that's why we got a decent outcome with Mr. Dershowitz's case.
There is so much to love about the changing of the seasons, right? What better way to soak up the best of this one than with a Michael Phelps swim spa by Master Spas? A Michael Phelps swim spa combines the benefits of a pool with the therapy of a hot tub. It comes in a variety of sizes to complement almost any yard, even if it's a small one. Master Spas worked with Michael Phelps to develop an at-home training and fitness solution that you can use year-round in any season, even the winter. Exercising in the water is a great way to include physical activity into your daily life. Relax after an afternoon of raking leaves or shoveling snow. The spacious swim area gives you room to stretch your tired muscles or relax your aching back. As your fall calendar fills up, or winter as it is about to be, a Michael Phelps swim spa will be the perfect place for you to spend some time together as a family. It's just like a little oasis for you and your family to get out to and spend 15 minutes together. The swim spa draws people outdoors, from kids to grandkids. They're all going to love splashing and playing in that swim area. Michael Phelps swim spas are 100% made in the USA by Master Spas. That's the world's largest swim spa manufacturer. A Michael Phelps swim spa is energy efficient too. You can use it all year long. Go to masterspas.com, put in the promo code MK, and that will save you $1,000 on a Michael Phelps swim spa or $500 on a Master Spas hot tub. Masterspas.com, promo code MK. Hey, thanks so much for watching. If you like what you just saw, hit the subscribe button for more clips and full episodes.